Hello and welcome to Employment Law Show. John Scholes here along with Lior Samfiru. I'll get it right. It's only been 6 seasons, but there you go. Welcome back once again. You have questions. We have answers. Stay tuned to the next 30 minutes. You're going to learn a lot. Phone number 1-855-821-5900. help@employmentlawyer.ca to reach out anytime. We're going to get to some phone calls as well, maybe terminationquestions.com. Lots of websites I'm going to throw at you over the next half hour, so one by one you will learn them. But a little later on the show, Lior, it's going to be 5 common questions about termination and the answers you need to hear. So we're going to get that in just a bit, pal, but we always start with the week that was. How are you?
I am doing great. Always a pleasure to be here. Always great to talk about employment law and workplace rights and hopefully help alleviate some of the stresses you may be feeling right now when it comes to your job, the ultimatums you may be facing, the loss of job, the lack of compensation that you're owed. This is the show. If you've always wondered about something to do with your job, your rights, no need to wonder anymore. We'll talk about everything you need to know right here, right now on the show. And of course, if you ever want to connect with me, my team, off air, not a problem. We'll give you that contact information throughout the show. And John, I don't recall in my 20 years of doing this, more questions, more uncertainty, more stress when it comes to workplace rights. I've been getting a lot of questions about vaccines and mandatory vaccines. So let me start off by talking a bit about that. I had a gentleman call me that asked me a question that I've been asked quite a lot over the past number of months, and that is this. My employer told me that I have to get my vaccine, and they told me that if I don't, I'm going to be put on an unpaid leave of absence. And what he wanted to know is, can that be? Can they put me on this unpaid leave of absence? And how long can this leave of absence last? No one's going to want to be on an unpaid leave of absence. So here's the answer. The answer is that your employer is not allowed, in most cases, to put you on an unpaid leave of absence. Nothing to do with the vaccine. Simply, an employer does not have a right to do that. That is a significant change, of course, to the terms of employment, meaning if you've been put on an unpaid leave of absence, you have a right to treat that leave as a termination of your employment. And that's true on day one. So I'm being asked, how long can they keep me on a leave? Well, they can't put you on a leave. So on day one, if you want to, you can choose to treat that leave of absence as a termination. So there's really only 2 options. Option number 1 is you wait and you don't do anything about it, in which case you sit at home and hope your employer is going to say at some point, come back to work. That's option 1. Option number 2 is you can say, no, I've decided that this leave is not acceptable to me. I'm treating that as a termination of employment, and now you have to pay me my severance. Keeping in mind, of course, severance has to be or can be as much as 24 months' pay. Now, regardless of the vaccine, you can get it, you don't get it. Ultimately, your employer cannot put you on a leave unless there's a government mandate in place. If there's a government mandate that says you must get the vaccine or your employer cannot have you there, then yes, your employer can let you go, your employer can put you on a leave. If there isn't such a mandate, if you're let go, you're owed severance. If you're put on a leave, that's a termination of your employment. And bottom line, if you're not sure what to do, what it means, what your rights are, let's connect and let's discuss it.
If you're put off or let go and you have a government job, you're in telecommunications, a railway, et cetera, and you're let go, do you still get severance, or in that particular case you do not?
So if you work for the federal government,
right.
Okay, so the federal government has announced if you work for us, Crown Corporation, or by the way, if you work in transportation, airline, railway, marine transportation, you have to get the vaccine. So there's a government mandate. In that situation, if you don't get the vaccine and your employer lets you go, there's not going to be much that you can do. But you may be federally regulated. For example, you may work at a bank, telecommunications. For those industries, as we speak right now, there isn't a mandate. So if your employer says, too bad, you have to get the vaccine, number 1, that could actually be a human rights violation. But number 2, if you're suspended, if you're let go, that would be a wrongful dismissal. You would be owed severance in that situation.
I know on the radio show we've been hearing a lot of people calling in. They've kind of, the ones who don't want to get vaccinated, it's their choice. They've chosen not to take the vaccine and continue working, and all the hazards that come along with that. But recently, the phone calls we've been getting on the show are, okay, the next step is now I don't want to take the test.
Right.
And they forced me to do the test. I'm not taking the vaccine, but now they're saying I have to do mandatory testing 1, 2, 3 times a week. How about that?
So the same thing applies there. So if you don't get the COVID test done, your employer says, don't get the vaccine, fine, but have COVID tests. If you refuse, in most cases, if you're let go because of it, you're going to be owed severance. You're going to be owed compensation. Again, unless there's a government mandate. So, for example, depending on your province, there may be a mandate in healthcare saying if you're working in healthcare, you have to get the vaccine or you have to agree to regular COVID tests. If that's your situation, your employer can do that. If that isn't your situation, if you lose your job because you don't have regular COVID tests, then ultimately that would still entitle you to severance.
Reaching out anytime. The website, as I mentioned, coming at you, employmentlawyer.ca. While you're there, you will learn more. You can contact Lior and his team. You'll also find a drop-down menu to catch past TV shows that we do, about a 30-minute show of what we do here, on the radio rather, an hour-long show. For years we've been doing those. We get a ton of phone calls every week, especially now in the last year and a half with COVID-19. So we'll get to one of those phone calls from the radio show now, Lior, and we'll talk about it.
My son. So he's for about 9 years for an international company. And basically, he's been told recently that they're wrapping up operations in Canada.
And what kind of a job is your son doing, and how old is he?
He's 35. But over the last 2 years or so, he's become their national operations manager.
What have they offered him?
I think 10 weeks.
Good old-fashioned severance question. That's refreshing.
Well, this is such a common situation, John, where someone loses their job, they're offered severance, and they always wonder, hey, is that enough? Am I owed more? Well, let me tell you what you're owed, and let me tell you what the answer is here. So we have a gentleman here, 35 years of age, worked there for 9 years, and was offered 10 weeks pay. Now, many people may say, well, 10 weeks pay, that's actually more than a week per year of service. That kind of sounds right. Nonsense. Wrong. Completely off. It's a fraction of what he's owed. And before I tell you what he's owed and how you can find out how much you're owed, let me remind you that this call that we took from our radio show is one of the most common types of calls that I get every day. Why? Because the vast majority of people, when they lose their job, regardless of the reason, are offered a lot less than what they're owed. I'm not talking, well, a couple weeks less than what I was owed. I'm talking to the tune of a year's pay less, even more than what they're actually owed. Chances are, if you lost your job, you're owed much more than what's on that piece of paper. But let's take it back to this caller here. I can tell you exactly how much that person is owed, but let's look at it visually. You can do this yourself. Pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. We have our severance calculator tool. So let's plug it into it and let's see what this person is actually owed. So he's in a senior managerial position, 35 years of age, 9 years of service. He was offered, how generous, 10 weeks pay. You see on the screen right there, he's owed 12 to 14 months pay. 12 to 14 months pay. Now, I did some math, John. Let's say you senior manager, good salary. If he's earning, say, $140,000, that difference is about $115,000 or more. So that's what we're talking about. So no, that 10 weeks is nonsense. It's a wrongful dismissal. Chances are, if you lost your job, you're owed as much or potentially a lot more than what you've been offered.
Outside the TV show, the radio show, you have questions for Lior. There's another website for that, really handy. It's anonymous, it's free, terminationquestions.com. Again, terminationquestions.com. You can use that anytime you'd like, and a member of Lior's team answers those and gets back to you with a full response indeed. We'll get to the first one for the show today. Lior, this comes from Adam, says, after working overtime for years without extra pay, I finally confronted my boss about it. I was fired a few days later without warning. I did get 2 weeks pay for severance. Is there anything I can do about the unpaid overtime?
So, John, there's so many wrong things about this employer, what this employer did, that I actually had to take some time and count them. Yeah. So let's start with the idea that, yes, overtime. You have to get paid overtime if you work the overtime requirement. Now, depending on your province, that could be 40 hours a week, that could be 44 hours a week, it could be 8 hours a day. In every province is different. But keep in mind, even salaried employees get overtime, okay? And the other thing to keep in mind is you get overtime if you worked it, even if the employer did not ask you to work it. Even in that situation, you're owed overtime. So that's number one, he's owed overtime. Number two is he approaches his employer about overtime and he is let go. Illegal. We call that a reprisal. You cannot be let go for standing up for your rights because you're asking questions about your overtime, your vacation pay, your minimum wage, what have you. You're protected. You have this dome of protection. That's what I call it around you. You cannot be let go. So this employer let him go. They're going to have to pay damages because of that. The third thing is, well, I was let go with 2 weeks severance. well, he's probably owed a lot more than 2 weeks severance, even if we forget about the reason he was let go. Depending on his age and position, length of employment, that could be as much as 2 years' pay. So we have unpaid overtime, we have a reprisal, we have a wrongful dismissal. Well, hopefully your employer doesn't do the same thing as his employer did. If you have any questions, any issues, any of this rings a bell or reminds you of something, let's talk.
You know, you did mention a couple minutes ago, but even if you has not been approved by your employer, you work the overtime. What if it's the case where they've told you not to work overtime? We don't have overtime here, but you got to get the job done, right? And you work it anyway. Do you still get paid, or do you get reprimanded for that?
If you work the overtime because it was necessary to work it, you had to do it, it was legitimate, you have to get paid for it, even if your employer told you don't do it. Now, in that situation, the fact that you worked overtime when you weren't supposed to may mean that you're subject to discipline. But ultimately, your employer has to pay for overtime that was worked legitimately.
All right. As I mentioned off the top, 5 common questions about termination you need to hear the answer to. That is coming up. But first, we've got to take a short break, which we'll do now. Reaching out, phone time, anytime, 1-855-821-5900. help@employmentlawyer.ca as well. We'll continue Employment Law Show. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thanks for hanging around. Employment Law Show. John Scholes and Lior Samfiru, the most positively reviewed employment law firm in the country. Samfiru, Tumarkin, LLP. You want to reach out, help@employmentlawyer.ca. Okay, Lior, let's get into these. 5 things, 5 questions about termination. The answers you need to hear. Number 1, I'll lob an easy one over the plate for you, pal. This is, does my employer need a good reason to fire me?
Yeah, I often get this question in various forms. Usually people call me because they're upset that they lost their job. And I understand that. If you don't feel you've done something wrong and you are let go, you're going to feel wronged. I get that. And many people have heard this term wrongful dismissal, which suggests that your employer can't just let you go. But let's talk about it from a legal standpoint. Generally speaking, an employer is allowed to let you go, to let any employee go at any time and pretty much for any reason, as long as compensation, as long as severance is paid. So an employer doesn't have to have a good reason. An employer doesn't have to have a reason at all, nor does the employer have to give a reason to let someone go. And oftentimes people say, my employer let me go. They said that it was a restructuring, and then I saw them posting the job, my job, online looking for people, so they're lying. And you're right, they're lying. But the reality is, from a legal standpoint, an employer is allowed to let you go, even if that reason was not true and they were not honest about it. Now, of course, your employer cannot let you go for discriminatory reasons. You cannot be let go because of your age, your ethnicity, your disability. That's illegal. No amount of severance is going to rectify that. But if it's not a discriminatory reason, you can be let go as long as severance is paid. So wrongful dismissal, going back to that term. Wrongful dismissal is simply a situation where an employee is being let go without full severance.
Number 2 is this, Lior, can it be fired without severance for performance issues or an honest mistake?
So we talked about the fact that you have to get paid severance. Well, let's break this down a bit. The only way your employer can avoid paying you severance is if you've done something bad, something that's so difficult to accept that you can't continue to be working there. In other words, it's the worst punishment for the worst offender. So the fact that you may have done something wrong, the fact that you maybe even did a few things wrong, does not mean your employer can let you go without severance, what we call a termination for cause. Now, if you did something wrong, your employer gave you a warning, you did it again, they give you another warning, then a final warning, well, at some point the employer can say, what more can I do with this employee? But if you haven't received those warnings, if there wasn't something that was very, very bad that you did, even though you may have made a mistake, maybe you said something you weren't supposed to, maybe the project didn't turn out the way you wanted to. Sometimes these things happen. That does not mean you can be let go without severance. You can still be let go, no question, but full severance has to be paid, again, up to 24 months pay.
Does the employer have to start building some sort of a case for performance and otherwise? Do they have to does it have to be written notice in that regard?
Yes. If an employer wants to let an employee go for cause, they have to do what I call build their case. So you have to be provided, first of all, told what the parameters are, what's expected of you. And if your job is not good enough, you have to be given a warning, an opportunity to fix the problem. At some point, you have to be given a final warning. And then, and only then, if the conduct continues, can you be fired for cause. A lot of times, what I've seen for many years, employers don't want to put in the work to get to that level. They just terminate someone saying, well, you made a mistake on this project, so we can let you go without severance. No, not at all. That's a wrongful dismissal.
A lot of questions about termination of employment. We've narrowed it down to 5 for this particular half hour. The big ones, this third one, Lior, especially in the last year and a half, has been absolutely massive. Does a layoff count as a termination? How about that?
So a layoff, a temporary layoff, a situation where you're put off work, a leave of absence, whatever you want to call it, is in the eyes of the law a termination in most cases. Bottom line is, in most cases, even during the pandemic, your employer does not have the right to put you off work. Call it a leave of absence, call it an infectious disease leave, call it a temporary layoff, it doesn't matter. If you're in one of those leaves, layoffs, whatever you call them, you have the right to treat that as a termination. In other words, you can accept it and stay at home and wait to see what your employer does. Obviously, that's your right. But you also have the right to say, that is a termination of my employment. I've decided that it is, and because I've decided, you, my employer, have to pay me my severance. That is not a complicated or a controversial point. These matters are not difficult to resolve. If you find yourself in one of those layoff situations, let's have a chat about it.
A lot of people have been off for over a year for that reason. Has the time accrued? So if you were a 5-year employee, now you're a 6.5-year employee, does that go towards your severance in that case?
Correct. Time spent on a layoff does count towards your severance. And by the way, other leaves of absence, maybe you were on a maternity leave for 2 out of the last 4 years, that time counts towards your entitlements as well. So yes, you actually, because of that, may be owed even more severance than you realize.
Another one is this: you are likely owed a severance package even if you were let go for cause or a contractor. How about that? Yeah.
Yes. So let's talk about, you talked about cause, let's talk about contractors. Oftentimes contractors are misclassified. I speak daily, John, with people that have worked for years, sometimes believing that they're contractors. So they sign an agreement saying they're a contractor, they pay their taxes as a contractor, the company they work for says that they're a contractor, and they think they're a contractor. And then employment, or then the position comes to an end, and the company says, well, we don't have to pay you anything because you're a contractor. Well, guess what? You're probably misclassified. If you work for a company for a long period of time, if you work for them exclusively, if you do what they tell you, you have to abide by their rules, their guidelines, they control you, you're likely an employee, and it doesn't matter what you believe that you are or what the company believes that you are. And if you are an employee, that means, as I've said, you're going to be owed severance if you're let go, just like any other employee. Again, up to 2 years' pay. But you're also in a situation where you have other entitlements: overtime, vacation pay, minimum wage, you name it, you're owed that as well. So being misclassified, very common situation, and does not deprive you from getting your full severance.
Next common question is this: are you owed severance if changes are made to your job, if you're harassed or forced to resign, something like that? Yeah,
so if your terms of employment are changed, if you're being put in a position where it's difficult to continue working, the law considers that to be a termination. Meaning, if you leave because of that, the law says it's as if you've been terminated, you're owed severance in that situation. That is what a constructive dismissal is all about.
That's number 5. I'm actually throwing in a final one, number 6, and that is this: should you talk to an employment lawyer before you try to negotiate a severance package? A lot of people think they can just go talk to the boss, right?
Well, I've been doing this for a long time. We have a team of 40 people across Canada just helping individuals with this. And the reality is that you need to do some education with your employer. They're not necessarily going to understand and appreciate what they owe you. So you're going to need to get us involved. The good news is, unlike with other legal issues, when it comes to severance, when it comes to losing your job, it's not difficult to resolve. It doesn't take years. It doesn't even take months. And in most cases, it can even be resolved without legal action, without even looking or seeing where the courtroom is. So because of that, do not be afraid of that legal process.
Most employers, if they're reasonably sophisticated, are going to expect you to at least come back and say, how about this? How about that? How about a little more here? How about a little more there, right?
Well, John, if your employer lets 10 people go, and all 10 are offered inadequate severance, which, by the way, is likely to happen, the employer can almost count that 8 or 9 of them are going to accept it and sign that dotted line without even batting an eye. So for that 1 or 2 people that actually know better, that's pretty good odds for that employer. Then they say, well, okay, we'll take those odds. Well, the point of this show is for you to be not one of those 8 or 9 people that will sign off on that severance, to be that 1 or 2 people out of 10 that will know better, that will get what they're legally owed.
Again, another way to reach out online, employmentlawyer.ca. That's where we get the phone calls from the radio show. Number 2 is coming right now.
I just was wondering if there's like a statute of limitations on the time from being let go or laid off until the time you can apply for it. Like, if you don't get a severance when they let you go, can you still go back and get one or ask for one?
It's a great question.
That is a great question, and it's certainly one that everyone needs to know about. So here's the answer. The answer is there's a 2-year limitation period. That 2 years starts from when you are let go, from your last day of work. So if you were let go a year and 11 months and 364 days ago, you still have that 1 extra day to pursue your entitlements. Once it's a day beyond the 2-year period, unfortunately, you're out of time and you cannot pursue it. If you've been let go, don't wait 2 years. Don't even wait 2 months. Let's talk now. But for those people that have been let go over the last 2 years, have not signed anything, you still have time to pursue your full termination entitlements.
And we still have some time in the show to teach you a lot more, so stick around. We'll get to it after a short break. In the meantime, 1-855-821-5900 is the number to reach that guy and his crew, and help at employmentlawyer.ca as well. We'll continue. This is the Employment Law Show. People think contractors aren't owed severance. Employmentlawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. Employmentlawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at employmentlawyer.ca. All right, welcome back. Employment Law Show again. John Scholes here. Lior Samfiru right there. He's the guy you want to reach out to, and his crew across this country if you're in Ontario and BC and Alberta as well. 1-855-821-5900. Reach out. Help at employmentlawyer.ca. And the website, employmentlawyer.ca, is where you can learn more. There's more content, contact there as well. Content, of course, and ways to reach out and catch our radio show at a station near you. Phone call number 3 from our very popular radio show, Lior, is coming up right now.
I was recently written up by my employer for what they call a customer mistreat. And what had happened is the customer had called in. I couldn't satisfy their requirements, and he got very belligerent and rude. Our program itself, it's based on opinion of the employer. Now, I personally don't feel I did anything wrong. I was called some very nasty names, but they ended up putting out what they call a final. So one more incident in 6 months, and they terminated. So what I did is I refused to sign it, and they said refusing to sign itself was an admission of guilt and that they could terminate me right away.
Yeah, well, it's nice. Let's just make up the rules as we want. Yeah, everyone knows it if you don't sign. No, that's silly. So let's be clear. The employer doesn't get to decide what is an admission of guilt. Okay, this is not the playground. Okay, we have rules here. We have laws. So not signing a performance review, a negative review, a performance improvement plan, whatever it is not an admission of anything. But the real question should be, should you sign and should you not sign? So first of all, he says he disagrees with being written up. So my question is, what does the document say? If it simply says, hey, by signing here, you acknowledge that we gave this to you, then you can sign it. It's no big deal. If it says by signing this, you agree that this is all correct and you've done something bad, well, if he doesn't agree with it, he can't sign it. So the point is, what are you signing for? Now, what I would prefer he does is he can sign to say that he's accepted it, he's received it, but then follow up with an email. Email works perfectly, text message works as well, saying, I know you wrote me up, but I wanted to be clear and on the record what actually happened. Here's what happened with this customer, here's what he said, here's what I said, and ultimately I don't feel I did anything wrong. You want to be clear and on the record. But not signing a document, not signing a negative review or being written up is not an admission of guilt. It's not something that the company gets to decide. It's like you saying, hey, company, if you give me something, if you write me up, it's an admission that I'm owed a pay raise. That's silly, right? But you can't make up those rules, neither can the employer. Again, if you're not sure, if you get a negative review like that, let's have a chat so that you respond properly.
Going back over to terminationquestions.com one more time here. This one is from Wes. Wes writes in, says, I've just been told that because our latest project failed to produce the results we were hoping for, everyone in my department will have to take a 20% pay cut. That pay may return depending on the results of our next campaign. Can they do that?
So no, an employer does not have the right, the ability to reduce your pay, even if it's because they're not doing as well. Just like if they were doing amazing, that doesn't mean that they have the obligation to give you more money. By the same token, they don't have a right to give you a pay cut just because they're not doing as well. So that is a constructive dismissal. So Wes, in this situation, can accept this. The problem with accepting this pay cut, he gives them the right to do it again. The next time they do it, he won't be able to do anything about it. Or he can say, not happening. It's a constructive dismissal. Same with you. If your pay is being reduced, even if it's because of the pandemic, the reality is that is not legal. That is a constructive dismissal, and you have rights in that situation.
Can it not even be a dollar of amount? I know sometimes when it's distance, if they move, if it's reasonable and you have to travel a little bit further, they can slide under the radar of that one. But how about pay?
Yeah, even with pay, usually anything below 10%, we're in a situation you're not going to be happy. Who's going to be happy with a 10% pay cut? But it's not arguably all the way to the level of a constructive dismissal. On the other hand, once we're beyond 10%, in this case 20%, no brainer, that's constructive dismissal territory. So you don't want to accept this because the next time it's another 20% and another and another. Before long, there's not much left there. You won't be able to do anything about it. You're better off saying, I think, constructive dismissal, I'm going to get my severance and move on to another job. And by the way, sometimes just you uttering the words constructive dismissal or telling your employer, I'm not going to accept that, may make them change their mind and back off because ultimately they know. Whether they tell you or not, an employer knows that they don't have the right and the ability to impose a significant pay cut like that.
Well, it's like I said a minute ago. If say you did really good on the project, you can't walk in and say, you're paying me 20% more.
Yeah, I did such a good job, employer, that I think I did a 20% better job than you expected me to do, so you got to pay me 20% more. Yeah. You can say that, but your employer's not going to do it. By the same logic, your employer can't decide to pay you less because things didn't work out for the employer the way that they wanted it to.
Again, terminationquestions.com is where we pull those questions and have for the last half hour. You can go there anytime, terminationquestions.com. It's free, it's anonymous, it'll get answered right away, so that's another bonus. The phone call, 1-855-821-5900, employmentlawyer.ca is the website we refer to. That's where you catch the TV show. And help@employmentlawyer.ca for email as well. We'll catch you next time, Employment Law Show. Thank you.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca.